SJC-11524, Commonwealth versus Griffin.
Thank you.
Mr. Fishman, good morning.
Morning. May it please the court, Neil Fishman here for the defendant appellant Christopher Griffin. I have a number of appellate arguments to address before this court, but before I do, I'd like to set my overarching theme here today, which is that this is a case in which it was uncontested that the defendant slit the throat of his 6-year-old daughter. His defense was insanity, lack of criminal responsibility. In circumstances such as these, or such as this, where the facts of the crime must have aroused an enormous passion and sympathy on the part of the jurors, I would respectfully submit that this court needs to work extra hard to make sure that the defendant got a fair shot to present his insanity defense. And I'm going to argue in a variety of ways that he didn't get a fair shot.
Could I ask before you get too far in that? Obviously, I mean, I haven't read the transcript, but just reading the briefs and your description of the witnesses who testified, I didn't see a description of a defense expert in the case. Was there expert testimony on lack of criminal responsibility?
No, Your Honor, the defense presented no expert testimony on lack of criminal responsibility. In fact, the defense did not put on a case. But as Your Honor may be aware, it's the Commonwealth's burden to prove lack of criminal responsibility.
I know, but there has to be something for the Commonwealth to rebut, though, doesn't there? I mean, what are they going to say?
Well,
I guess they weren't entitled to. So they didn't have an expert either, but I don't know.
the Commonwealth did not have an expert. And I would submit under these circumstances, now I know there's various decisions of this court that says the Commonwealth doesn't need to have an expert. But these circumstances, I would say, are somewhat unique because in this Commonwealth's case, you have, it's replete with evidence of psychiatric illness. He's on various medications for psychiatric illness. He's suicidal before the crime, during the crime, after the crime. There's no dispute about this.
Well, I mean, what he did was painful for the child's family, but I mean, there has to be some explanation that just because this is a horrible act doesn't mean that he lacks criminal responsibility. They're two different things.
I agree, Your Honor. I would just return, I don't want to get into a circle with Your Honor, but the burden was on the Commonwealth to prove lack of criminal responsibility. And
I'm sorry, go ahead. Okay, so there's some evidence in the record that he suffered from a mental illness and had a history of mental illness, right?
severe depression, bipolar, suicidal.
Okay, you're halfway there. In order for there to be an insanity defense, doesn't there have to be something in the evidence that suggests that he either could not conform his conduct to the requirements of the law, or, and I just forgot the other alternative prong.
That he couldn't appreciate the
wrongfulness of his conduct. So where's the evidence of one of those two, or either or both of those prongs?
I'm sorry to interrupt, Your Honor. It's right there in the Commonwealth's case. In the interrogations, which were, and the cops, who, at least one officer who did the interrogation testified. So the interrogations are played for the jury. And in the interrogations, the defendant says he's getting commandments from God to kill his daughter. Why is God commanding him to kill his daughter? Because his daughter apparently is being molested or has been molested by another child in the household. That's a commandment from God. That fits Your Honor's second prong. Under these circumstances, it was,
But
it was
what was the commandment telling him to do?
to kill his daughter.
Well, it was a conversation with God, right? But no, I'm not disagreeing with you, but it was sort of God directed that this was the best way to protect and save his daughter from molestation in North Carolina.
Your Honor, if you look at the interrogations and if you look at the witness descriptions of the interrogation, it's a conversation, it's a debate with God, but it's also God telling him to do this. In fact, Detective Archer, he testified that defendant said it was an absolute instruction from God to kill his daughter to save her from future abuse, to send his angel back to God. That's on.
To have somebody, some expert saying that this is not just the defendant saying that because that's his defense in this case, but that has to be connected in some way by expert testimony to what this person was experiencing at the time. That's what he says when he's being questioned, but the Commonwealth isn't obligated to accept that or assume that the jury's going to believe that.
Well, I would just say a couple of things in response to that. One is that the argument that it's self-serving, I frankly don't understand the argument because this is, after all, the Commonwealth's case. It's a Commonwealth's evidence. And then I would return to the fact that the burden is on the Commonwealth to prove that defendant was criminally responsible. There's so many, it's the law stated in the negative and the affirmative is somewhat confusing.
Yeah.
I do have some other arguments to press. I realize
Before you leave this, am I correct that the judge indeed gave the criminal responsibility instruction here?
That's my recollection, indeed, yeah.
Okay, so the jury was instructed that they must find beyond a reasonable doubt that he was criminally responsible.
I didn't, in reviewing I didn't see an issue with regard to the instruction on the insanity defense.
And the Commonwealth's theory and sort of reflected in its closing is all the circumstantial evidence showing that actually he did have criminal responsibility. Right? I'm not saying jury had to believe it, but it was very much a joined issue at trial. That's all I'm saying.
Your Honor, that's correct. I'm glad Your Honor's question brings me to what I think the most forceful argument here, which is that the Commonwealth, in its closing argument, really engaged in very highly improper remarks that prejudice defendant's right to a fair trial. And
Before you get into that, and I think it may be something of a segue into what you're going to say, but I know that our case law says that the insanity defense can arise without expert testimony, but I'm wondering whether that needs to be re-examined. If the insanity defense itself is something that is beyond the ken of the ordinary person, and that the question whether or not somebody is unable to conform their conduct to the requirement of the law or appreciate the wrongfulness of their conduct isn't something that requires some expert testimony, which did not occur here. How could the jury even conclude on the evidence that was in the record without the assistance of expert testimony? I think this may go to Justice Hines's question.
I'm all for a new rule that says the prosecution, in its burden to prove criminal responsibility, has to put on an expert.
No, I'm not saying that. Doesn't the defendant have to put on some kind of expert testimony?
Well, Your Honor, I'm just gonna, frankly, I'm gonna punt and say it's the Commonwealth's burden. So I understand what Your Honor is saying.
But it's only the Commonwealth's burden if the issue of insanity has been introduced into the trial.
If there's a prima facie case of insanity, and here there is.
But where's the expert testimony that could conceivably assist a jury to conclude that the defendant was insane?
Well, Then I would say, Your Honor,
Or to raise the burden being
I
shifted
couldn't
to the
speak to,
Commonwealth?
I couldn't speak to a new rule, but what I would return to here is there's plenty of evidence, circumstantial evidence brought out in the Commonwealth's case that the defendant is seriously mentally ill.
But that's
So
the-
why isn't your best argument that counsel was ineffective for not presenting it in this way? I mean, this is very difficult, what you're trying to do. It's rolling a stone up a hill.
I appreciate that, Your Honor. As Your Honor is aware, ineffective assistance of counsel claim on direct appeal is tricky business.
Well, so you were representing him, motion for new trial.
Well, I don't want to get into attorney-client stuff or work product stuff, but it's certainly something I have entertained. Can I move on to some other issues here?
You can move on to the closing.
Yes,
but-
with
and-
regard to the closing.
And at some point, you need to, why don't you move on to the closing?
Yeah. I'm sorry, I didn't mean for that answer to sound discourteous. I just,
I didn't take it that
Okay.
way. Go right ahead.
yes, with regard to the closing, in the closing argument, the Commonwealth says that the defendant's actions were inconsistent with mental illness, and the Commonwealth argues that the sanity of the defense was self-serving, and that his actions before, during, and after the homicide were inconsistent with mental illness. And the Commonwealth gives various examples of how the ways that the defendant conducted himself that were inconsistent with mental illness. But what's going on there, quite frankly, is the Commonwealth is testifying, the prosecutor is essentially testifying as an expert mental health witness.
Well, where was the expert testimony that triggered the obligation to present an expert response?
All I would say, Your Honor, is those arguments were improper, and they were unnecessary.
Well, why is it improper for the Commonwealth to point to acts or statements that are in evidence of the defendant and say, this indicates, to argue, this indicates that he knew what he was doing, that he understood X, Y, or Z? I mean, I'm not sure why is that improper?
Well, because the Commonwealth is doing more than that. They are essentially testifying as an expert witness. And I want to get to my examples here. Aren't
they wasn't the prosecutor suggesting that the jury could come to these conclusions, that he was not mentally ill?
I think the argument went further than
But
that.
were they really arguing that he wasn't mentally ill, or were they arguing that the jury could conclude that he had criminal responsibility at the relevant time?
If I could just get to the exact quotations, because I think that'll help all of us here. So here are the quotations from the argument. So the Commonwealth argued that his conversation with God was not consistent with someone who's suffering from a mental illness. The way that the defendant was acting right around the time of this homicide is not consistent with someone who's acting mentally ill. And what about his behavior right before the murder? Again, I suggest to you, not consistent with someone suffering from mental illness. The Commonwealth concluded, so again, those are statements that could come from the mouth of an expert witness, but I think it was improper, highly improper.
But I mean, you've got a lay jury who has to evaluate whether or not the defendant's criminally responsible. They've been given no experts by either side. Of course, they're going to have to operate on their common sense and general understanding of mental illness in the world. So they have his intricate planning of the crime, his getaway. They could see him in the interviews. Those were, I guess, videotaped, correct?
Yes, Your Honor.
So they're looking at him on the day of the killing. They had a lot of information in which they could evaluate that. Why is that not, why can't the prosecutor argue that?
The prosecutor can argue what's in evidence. The prosecutor, I would submit, cannot argue that that evidence disproves mental illness because that's taking a leap.
So your thesis, I think, is you've raised, or your trial was raised, the issue of lack of criminal responsibility through various evidence, but mostly his statements about the debate and conversation with God, and his records that he talked about. And so then you say the Commonwealth obviously has the burden to prove beyond a reasonable doubt that he had criminal responsibility, and it may be okay for the Commonwealth to point to actions and say, this indicates he knew what he was doing. But I think what you're criticizing is to use things like this is inconsistent with mental illness because that is something that only an expert could say.
Thank you, Your Honor. I don't think I could have said it better.
Is that where you're coming from?
Absolutely. I would like to shift the conversation.
Well, wait a minute, before you shift it, I take it the defendant at trial was asking the jury to believe that the conversation with God was a real fantasy in his mind. And the prosecutor was perhaps suggesting that no, that it was self-serving, that he was not having a conversation with God, but in fact was planning a crime.
Your Honor, I don't see what Your Honor is saying as inconsistent with what Justice Botsford is saying.
Except that the prosecutor may be arguing that this is what he was planning was not a result of a conversation with God, but was something that he himself totally, with criminal mens rea, was carrying out.
If that had been the argument, I don't think I would be raising that on appeal, because once again, the argument was saying various actions of the defendant, and there's a whole litany of actions that the prosecutor goes through, and the prosecutor says over and over, inconsistent with mental illness, inconsistent with mental illness, and there's not enough evidence in the record to support those arguments. There's no evidence in the record to support those arguments. Those arguments needed expert testimony to buttress them. I would like to wrap up by discussing the Mutina instruction, which I came in preparing for oral argument.
Before you get there,
Yeah.
did the defendant give notice that it intended to pursue this defense?
Insanity defense?
Yeah.
I'm not sure if there's I don't know what sort of, I frankly don't know what the notice requirements are, but it was an uncontested feature of this trial that the defendant was pleading insanity, and that's the way the trial was litigated.
But if I don't think where the notice and the cross-examination happens is if the defendant says, well, if there's, you have to give notice of the insanity defense, but where the Commonwealth gets to examine the defendant through, an expert gets to examine the defendant is where there may be reliance on things that the defendant said, right?
That may be, Your Honor. None of those are features in this transcript or in this trial.
When you say that the Commonwealth was obligated to put on an expert, could the expert have interviewed the defendant absent the defendant's calling an expert of his own?
No.
I would think there would be some sort of Fifth Amendment issue there, Your Honor. I don't know. If I could move on to the Mutina area, which is very interesting. In preparing for oral argument, I came across this court's fairly recent decision in Commonwealth versus Chappell, and I told the Commonwealth about it as well. That case stands for the proposition that the Mutina instruction is not a defense-friendly instruction. And that's what I argued in my brief before Chappell came down. I looked at this instruction and reading it, and I thought, well, this is strange. It's supposed to be a defense-friendly instruction, but it sure doesn't seem defense-friendly to me, because if you read it, there's an inescapable conclusion that if a defendant is acquitted based on the insanity defense, it's anyone's guess whether, when, and how soon he will be released into general society.
Is it your view that Mutina is not accurate in terms of its characterization of the law?
Well, it's my view that given what I'm reading in Chappell and its revision of Mutina, that under these circumstances, defendant is entitled to reversal, because that is, to return to my theme, the chances to get an acquittal under, as this court is well aware, to get an acquittal under insanity defense is a rare thing. And with the facts like this,
Sisyphean task, one might say.
Pardon me?
A Sisyphean task.
Yes, a Sisyphean task, yes. And where the facts are this horrific, defendant, the so-called friend of Mutina was no friend at all. And defendant was prejudiced by the instruction. I understand his own lawyer asked for it, but he should have been more careful. There were alternative instructions he could have asked for. The new instruction in Chappell is much, much more defense-friendly. I would ask the court either to reverse Mutina, overrule Mutina, or reverse the convictions for the arguments related in the point 4 of the brief related to this consequences of a not guilty by reason of insanity verdict, and in light of its new decision in Chappell. Thank you very much.
Thank you. Ms. Cho, good morning.
Good morning. May it please the court, I am Yomi Cho for the Commonwealth. I'd like to just clarify the record regarding this expert. Over $13,000 was awarded to the defendant just for the sole purpose of retaining an expert. I believe there were 2 at least consulted by the defendant. In the end, no notice of expert was actually given under Rule 14, as you're well aware, that if the defendant intends to use an expert during the trial, then the Commonwealth is entitled to notice, but we were never given that. And in the end, no report or any kind of reciprocal discovery regarding the defendant's experts was produced. On the other hand, the Commonwealth did engage Dr. Greenleaf, who had been the doctor assessing him for competency, who clearly was found competent to stand trial. The opinion of the doctor was included in the report, and that was disclosed to the defendant. And I think on the penultimate day of the trial, the Commonwealth indicated to the judge that we have Dr. Greenleaf ready to testify as the last witness for the Commonwealth. Then the record goes silent as to why the Commonwealth did not produce the expert in the end.
This would be a rebuttal witness, but it didn't happen, or is that right? Or was it still part of the direct case?
I believe part of the direct case, but I try to figure out what happened, but the trial prosecutor could not remember, and there was no clues within the files as to why he was not called. But
Maybe because defense counsel said, we're not calling anybody.
perhaps. I think in the end, this case is a good example that the Commonwealth should be given the freedom to present evidence of criminal responsibility in any way that it finds most compelling. I think in the case, without the expert's testimony, it was very, the evidence was strong that the defendant was, in fact, criminally responsible. At most, the defendant perhaps suffered from depression and maybe bipolar disorder, and certainly he stated that he was suicidal in the past. But the evidence was not that he was, in fact, suffering from any of these diagnoses, even if they were true. At the time of the murder, it's not enough that the defendant claims that he was suffering from some sort of mental illness in the past. He had to have suffered from these depressive, he had to have experienced some sort of depressive episode at the time of the murder, but that was not the case here. Further, even if he was experiencing some sort of mental disorder at the time of the murder, the evidence is that he was acting in such constrained, strategic, and restrained manner at the time of the murder that the jury could infer that he was, in fact, capable of appreciating the criminality of killing his daughter, and he was also capable of not killing his daughter. I think on that evidence, the evidence was strong, beyond a reasonable doubt, that the defendant was, in fact, criminally responsible.
What does the record show as to when the defendant apparently had this conversation with God in relation to the date of the crime?
The claims about God, which were made only in the police interview. So there were 2 police interviews made, conducted, and they were recorded, and they were both within 12 hours of the murder itself. It was very quick.
But when did the defendant say in those statements to police, when was his last conversation with God in relation to the time of the murder?
Oh, I see. He said that he was having this conversation in the hours leading up to. So when he's in the camper, getting angry about it, getting angry about this Deborah moving to North Carolina with Katie, he was thinking about it and praying about it, and he was angry about it. So I think in those moments he was having a conversation with God, if we are to believe that is true.
Did he also say, but, and I don't
and
know
then
whether he
during
did,
it-
but yeah, when he was with Katie
Yes.
before killing her,
Yeah.
also talking to God at that time?
Yes, he did claim that. He said, I don't want to, God, I don't want to kill my daughter, but he said that God told him that, that Katie, his little angel, had to be sent back up to heaven because that was the only way to protect her from further molestation, either from Bobby or from any other men in Deborah's life. That is what he claimed. But I think what was very compelling evidence that's totally fabricated is this phone call with his mother that I've included in the brief. That was introduced to the jury. The recorded phone call with his mother was played for the jury, and it was very powerful. And what it said was, within 7 months of the police interview, he was on the phone with his mother, and the mother had confronted him about this claim about God. She said, I read in the newspapers that you told the police that it was God who told you to kill your daughter. And he was very quick to deny this is not the case. He said, that's not true, Mama. I didn't tell them this. I said rather that I prayed to God that he would give me 2 choices, either, and she asked, what 2 choices are you talking about? He went silent, and then she asked him, are you saying that you wanted God to give you 2 choices, either your life or her life? And I think then the phone conversation cuts off. So that was very powerful evidence on top of the police interview itself. It may be a little subtle, but the way he talks about God and God's command that he kills Katie was rather theatrical. He used this very feigned mosquito-like voice, and he would use this voice only when he's talking about God to appear very sympathetic. That was highly theatrical. But then when he was talking about other things, like how he hated Deborah for making him homeless, cutting off his cell phone, then he used very angry, normal voice. And then he used a different voice entirely when he was talking about tools and going fishing. Then he was relaxed. So within 30 to 40 minutes of this police interview, the only times that he was talking about God, he was very theatrical. I think from seeing something like that, the jury could infer he was fabricating this. Certainly there was no evidence that he was psychotic or experiencing any kind of mental disorder that would lead him to hear voices or to dissociate from reality, where he has this second voice playing in his mind other than his own inner voice.
If I can ask you to follow up on Justice Spina's question as to whether we should require a defense expert in order to trigger the obligation of the prosecutor.
The determination of criminal responsibility is not the same thing as a medical diagnosis of someone being suffering from some sort of mental disorder. So, but since there is that component, whether this defendant suffers from mental disorder, I think an expert could be helpful in most cases. But in many other cases, perhaps not, for two reasons. One, experts were never given this court has never given experts the benefit of conclusiveness. It shouldn't be the case that we require trials to be conducted with experts where the experts are given that kind of power in that factual determination, which is obviously for the jury to do. And second, if there's no evidence or some item introduced at trial that doesn't require, that is so complex or technical that it needs an expert's assistance, in that case, then the expert should be required to be called. But if there is no such evidence, which is the case here, then one should not be required. I think the trial counsel should be given the freedom to present the evidence in the most compelling way that they believe. And if the expert is required, then so be it, but not be required by the court to always call one.
Do you agree that the evidence here was sufficient to require a judge to instruct on insanity?
Marginally so, Your Honor. The standard on whether the defendant is entitled to it, the instruction is rather low. I think it's something to the effect of if any evidence is presented that, if believed, raises a reasonable doubt as to criminal responsibility, then the defendant is entitled.
I take it then you agree also, I think you have to agree, but do you agree that the burden was on the Commonwealth to show beyond a reasonable doubt that the defendant was criminally responsible?
Absolutely. And we've satisfied that more than sufficiently with the evidence that was presented. The evidence was ranging from witnesses who interacted and knew the defendant very well, saying that the defendant acted normally. So that's 2 weeks before the day of, he was acting normally. And he was capable of something as mundane as returning a video that was due to the library hours before committing this murder. And then there's the facts surrounding the murder itself. I won't belabor the point, but I think it's very compelling that the defendant was incredibly strategic, such as he cut the phone cord before he went into the house so that people wouldn't be able to, call out 911. He took off the boots so that when he's walking around the house, he wouldn't be heard, and such other very critical information. He didn't drive the Jeep, but rather walked over so that Deborah wouldn't hear him coming towards the house. And then there's the interview itself. He was very coherent, clear, and cooperative. I think that's another very powerful piece of evidence that the defendant was criminally responsible.
Do you think, what do you think, accepting all that, of the point made by the defense that in closing argument, it would be okay for the prosecutor to talk about acts and, and drawing inferences from acts, but to actually characterize that's not mental illness, that kind of talk is something beyond the ken of the prosecutor unless he or she was a trained mental
Right,
health.
but even so, I think the argument by the prosecutor was more than appropriate in this case. She marshaled the evidence, lined them up, and said, I suggest to you that this is not consistent with mental illness. And combined with the judge's instruction that this is not, the arguments are not evidence, I think the juror could very easily take that to mean that this is an argument. It's a suggestion for the jury to draw in the end. And I think in the Commonwealth's brief, we have linked up all argument with evidence. So I can very confidently say that the arguments were taken as arguments and that they were, in fact, grounded in the trial evidence. Thank you. We ask that you affirm the verdict of guilty.
Thank you.
Thank you.